Good evening, everyone. How's the sound level? Can you hear? Is it okay? Can folks in the back of the room hear okay? Or do we need to turn it up? Up more? Okay, we'll speak a little louder. Welcome to the Boston City Council on the road. We are here with the Committee on Planning, Development, and Transportation. My name is Michelle Wu, and I'm proud to have the committee assignment from our council president to chair this particular committee. I'm joined by my colleagues, our City Council President, Andrea Campbell, and also District City Councilor Kim Janey. And I'm sure others will join us throughout the evening. We are here for a hearing on docket number 0449, a matter sponsored by Council President Andrea Campbell and referred to this committee on March 21st, 2018. I want to remind everyone that this is a public hearing that is being recorded, and it will be broadcasted on channels Comcast 8, RCN 82, and Verizon 1964, replayed on Saturday, April 28th at 5 p.m. Please silence your cell phones and other devices, and remember that we will take public testimony. So if you wish to testify, remember to sign in on the proper sheet right at the door where Juan is. You can ask him any questions. And, okay, we'll get to that part later. Again, this is docket number 0449, order for a hearing regarding as-of-right zoning projects and exploring imposing notice requirements and other community-informed conditions. So I'll turn it over to our sponsor and council president for an opening statement.
Can you hear me? Perfect. Thank you, Councilor Wu, and thank you, Councilor Janey, for being here as well. I just want to be quick so we can jump right in. This hearing is the beginning, I hope, of many conversations related to development processes in the city of Boston, not only for as-of-right projects, but even projects that require conditional use applications or variances. The context for this particular hearing order came out of the situation of Popeyes right here in Codman Square, but I think there are many examples that other councilors could point to as an example as to why we needed this hearing now. So for the Popeyes situation, for those who don't know, it was a restaurant that came before the Codman Square community asking for their permission to open, asking for their support with respect to a conditional use application. The community said, no, we don't want that in our community. We're looking to do healthier food options for our residents. The applicant then went back to the zoning board, or to the zoning board, ISD. Thank you, Commissioner. To ISD for an allowed use or as of right permit. And that meant that the place or the parcel of land that they were looking to open on was zoned for a commercial use that they could use as of right. That meant they didn't have to go through a community process. So, to the shock of many residents in the Codman Square neighborhood, they were walking down the street, they saw Popeyes under construction, and were angry and upset, and of course called our office. Rather than focus tonight on the Popeyes, this is a hearing to discuss the process in general and what we can do differently going forward to involve community, not only in projects where they require some variance or some approval from the City of Boston, but even looking at those projects that are as of right, where they may not actually need an additional approval to open because the parcel is zoned a certain way. What can we do in those situations to also afford community more voice in those particular projects? The Popeyes has since been built. They went before the licensing board, and that license was actually denied, so they're not operating currently. I have frankly mixed feelings about that because they followed some protocol and then constructed their restaurant and went to licensing expecting to get it, and they were denied. So now they've invested obviously money and built this restaurant where they can't open anymore. So how can we talk about making sure that these processes of zoning, ISD, and the licensing department are all connected? So these are conversations that I hope to have tonight and hope to be a part of the dialogue. Thank you, Councilor Wu. I want to, of course, turn it back over to her in case Councilor Janey has anything to say. But I want to thank the residents for being here tonight. It's a little warm in here, so bear with us. But we wanted to do it in community, and we wanted to do it in the evening time so that folks from the community could participate. So thank you to my residents for being here, and I look forward to a robust conversation. Thank you.
Thank you, Council President. Councilor Janey.
Thank you so much. First, I would just like to say thank you to Council President Campbell for sponsoring this important hearing, and to Councilor Wu for holding this hearing in the evening, holding it out in the community so that residents can attend. This is a very important subject matter. Even though District 4 is not my district, this is an issue that we are facing citywide. I certainly get a lot of complaints or concerns being raised by residents in District 7. There is a project that is happening now that residents have not been informed of because it's as of right. And with so many lots being developed throughout the city of Boston, not all of which will require, a variance through zoning, it's just important to make sure that residents have a voice, that they, at minimum, are informed about what is happening right in their neighborhood. And so I'm, excited to hear and learn and hear, particularly from folks who are attending tonight. So thank you so much for being here. And thank you.
Great, thank you. We'll turn it over then to our administration representatives, Commissioner and Jeff. Feel free, whatever order you like, please introduce yourself for the record and feel free to give a statement.
Sure. Good evening. Thanks for inviting us here tonight. My name is Buddy Christopher. I'm the Commissioner for Inspectional Services for the City of Boston. ISD's responsibility is to enforce the building code, the zoning code, and the sanitary code. We are often asked about how things get through the process. When a community doesn't want a project, but yet the project still is allowed to go through. And we can answer these questions. They're not always the answers you want to hear, but it's the truth, and 99% of the time it's the law. And basically, the definition of what an as-of-right project means. It's basically that the project is not asking for zoning relief or building code relief. The City of Boston has got an entire zoning code. When it was first written back in the 70s, it was like 69 pages. I think it's like up to 12,000 now. So every community has its own nuances and its own uniqueness. When a project comes into ISD, we don't have an opinion on the project. We analyze it against those three codes to see if it meets the requirements. If the project meets all of the requirements, and I mean all of them, then the project is considered as of right. By that, it means that it has already met all the zoning statutes, all the building code statutes. We have not only, the responsibility, but it's an order for us to give them a building permit to proceed. And that's the way that we act on it. The community gets involved when a variance is asked for. And the only ones who can give variances is the Zoning Board of Appeals. In ISD's world, if the requirement is 2 feet and it's 1 foot 11 and a half inches, it's not 2 feet. So we deny it. If the applicant wants to continue that and ask for relief, they've got to go to the Zoning Board of Appeals. The Enabling Act of the Zoning Board of Appeals, it's online and it's in all these wonderful books about the legal logistics of how it works. If you like reading this stuff, it's very interesting. If you don't like reading it, it's very boring. I happen to like reading. So this is what we adhere to as we move forward. And the Board of Appeals' responsibility is to listen to the community, listen to your elected officials, listen to the applicant, and then their role as an autonomous body is to make a decision which they think is best for the city of Boston. You don't always agree with it. There's always half the room is happy and half the room is unhappy. But that's the way the process works. And I can go into more detail as we go forward. Jeff, would you like to add anything?
Thank you, Commissioner. Good evening. Thank you for having us here tonight. My name is Jeff Hampton. I am the Senior Zoning Planner for the Boston Planning and Development Agency. I'm also the Executive Secretary of the Boston Zoning Commission and the BPDA's liaison to the Zoning Board of Appeal. So pretty much my job is anything that is zoning related in the city of Boston that lands on my desk. The job of the Boston Zoning Commission is to enact the zoning laws for the city. You know, to take into account land use dimensions, health, transportation. They are tasked with enacting the zoning laws. They are also tasked with approving institutional master plans. So the Harvards, Northeasterns, BC, the city knows what they're going to build 5, 7, 10 years out. They're in charge of approving those plans. They're also in charge of approving large-scale development plans that is a predictable zoning and approval tool. An example is South Bay. The apartments over there, the restaurants, the movie theater was approved through a development plan over in that area. So the Zoning Commission's job is to not grant the zoning relief that the Board of Appeal does, but to actually enact the laws that Inspectional Services enforces, and if applicable and appropriate, the Board of Appeal grants variances to. And I'd be happy to answer any questions regarding anything zoning related.
Great, thank you. So I'll turn to my colleagues now for questions. I do want to recognize that there's staff in the room from Councilor Michael Flaherty's office and from Councilor Mark Siomo's office. I'm sure others will come in as well. So we'll do questions, and then right now we only have 4 folks signed up to testify, so maybe I'll take at least a few and ask our panelists to stay, and maybe they can respond to some of them as a group after that as well. Council President.
Awesome. Thank you, Councilor Wu. And Commissioner and Jeff, thank you both for being here. You're a wealth of knowledge, so I appreciate you being here tonight. So I have questions that I have come up with, but also questions that come from folks either who couldn't be here tonight or residents who are in the audience but prefer not to get up there. So bear with me. And I will only ask some questions for a certain period of time so that Councilor Janey and Wu could also have time. And I may come back for a second round. But just, I think, for the lay person who doesn't understand Article 80, for example, as of right projects, the zoning board, can you walk us through, just in layman terms, the process overall for an as of right project, a conditional use, an Article 80? I think some people have heard those terms, often use these terms interchangeably. And when walking us through that process, what is required? So what notification is required, when, who sends it out, who's responsible for letting community know? What exists right now?
I'll take the base zoning, you do the Article 80.
Thank you.
The normal process to do a project is ISD encourages you to come in before you apply, but the process is to apply. You can do that online to get the process going. Depending upon the size and complexity of the project, there are various elements and information you need. Basically, what you need is a set of drawings that articulate what it is you're trying to do. You have to identify the location of it and place the structure of the building on a site plan so that we can analyze it against the zoning. The as-of-right project comes into ISD. You start at count of 1, you fill out the application. Count of 2, it's reviewed for its consistency with the information that's needed, and then it goes through a plans examining process so that there are 9 staff members now that review these projects to make sure that it's in conformity with zoning and the building code. If everything is all right, it is then sent back upstairs. The applicant is notified. It usually takes between 27 to 30 days. You are issued your building permit, you go forward. There is no public notice required. There is no newspaper printouts or anything to do with that. And then it goes into the normal ISD process for review during construction. There are 2 other considerations in zoning. 1, it's allowed. 2, it's conditional. 3, it's forbidden. If it falls into the category of conditional or forbidden, it's talking about the use. Like a gas station is not allowed in a residential neighborhood. So in those cases, it's a use variance you're looking for. The other zoning issues are things about massing and density. How tall is the building? How wide is it? How far away is it from the property line? In some cases, what the materials are made out of, if it's in a historic area. If there is a violation that has to go to the Board of Appeals, ISD issues a rejection letter that says these are the articles that you're in violation of. The applicant then has to go over to our appeals board, file for a zoning board of appeals. Now, the way that we do this under Mayor Walsh is that the applicant comes in and applies. ISD will not schedule that meeting until we have a conversation with the Office of Neighborhood Services. Office of Neighborhood Services decides whether it's an abutters meeting, a community meeting, or a bigger meeting. And the real big meetings Jeff will get into about the Article 80. There is a 20-day public notice period for projects that need variances. So the direct abutters within 300 feet of the property will receive postcards. We post it in the newspapers. We post it on all the city online social media so we can get as many people involved as we can. During that period, there is the public interaction, whether it's a community meeting or a abutters meeting. Everybody goes there to voice their concern, compliment, or complaint. Office of Neighborhood Services responsibility is to listen, not to mandate, not to guide the discussion, but to listen to what you feel about the project. Their responsibility is then to take that back to City Hall so that they can render their opinion to the Zoning Board of Appeals for the people that could not make it to the meeting. The project is scheduled at the Board of Appeals. We have two types of zoning. One is 1 and 2 family small business zoning, which takes place on Thursday night at 1010 Mass Ave. And then we have the regular zoning, which takes place on Tuesday morning. It's every other week on the 8th floor, room 801. It's noticed, everything is done, the meeting is scheduled. The applicant gets the opportunity to present the case to the 7-person panel of the Zoning Board of Appeals. And they get to articulate whatever they want, whether they want to go into the nuances of the law, whether they want to go to the community benefit, or they want to, whatever they want to present, they get to present. The board listens, asks questions. Then it's opened up to the elected officials. Most of the elected officials are really well versed in these projects, so they know pretty much where they stand and what their issues are with them. So either the councilors themselves or state representatives or their representative will be there to present the elected officials' opinion about the project. The board then opens it up to public discussion. They usually start with those in favor, and they hear testimony. It's totally at the board's discretion how much they listen to or how much they don't listen to. I have been at meetings where there's been 50 people in favor of a project. The board doesn't want to listen to 50 people say the exact same thing. So they'll listen to people, hear a few of the comments, and then poll the people. All those people in favor of this project, show of hands. The people who are opposed to the project get the exact same audience as far as their thoughts and ideas, same process. Now the board can make, I guess, 3 to 4 decisions. The applicant always has the opportunity to withdraw. It's very interesting why people withdraw projects. Sometimes they withdraw because there wasn't a good enough community process, and they know that the board's not going to vote on it. Other times they feel that they haven't presented their case properly, and they want a second shot at it. All perfectly allowed. The board has to vote on whether they're going to allow them to defer the project or not. When it comes to the actual vote, the board has 3 options: approved, denied, and denied with prejudice. Approved is just what it says it is. They approve it, they can add caveats to the decision. BRA design review, it's actually anything they can add to it. That's usually the one that they add to it, or if there's some nuance about the design, they have the authority to make comment. Denied is simply that, the project is denied. The applicant cannot bring the project back for a year without substantial change to the project. If the project is denied with prejudice, without prejudice, then it's
Come in tomorrow.
the next day. They can come back with the project. So those are the guidelines. Once that process is done, ISD provides a secretary at the board that records all this information. It's filmed and everything and publicized. The legal decision is then written back at ISD in our legal department. It then brought back to the board that heard the case. It's very important because there are 7 primary members and 7 backup members. But the 7 members that heard the case are the ones who have to sign the decision, no matter what it is. Comes back to the board, it's signed. It then comes back to me. The way the ordinance reads, the building commissioner has to be noticed. They just tell me it passed. They show it to me and it's passed. That starts what's called the 20-day appeal period. At that point, anybody in the city of Boston can appeal this project. But you gotta have a reason to appeal it. To not like it is not gonna hold water. At the end of the 20 days, if there is no appeal, then the Board of Appeals orders me to issue the building permit. All right, that's your standard average project. Then there's the Article 80 projects.
Oh, don't stop.
No, I
Don't stop.
Thank you,
I have
Commissioner.
no water, so keep going.
So Article 80, as Councilor Campbell, I believe, mentioned, those are large-scale projects. There are specific thresholds that are triggered for these types of projects. And under Article 80, which was implemented back in 1996.
Sorry, Jeff, could you lean into the microphone a little
I'm
more?
sorry. Article 80 was adopted by the Zoning Commission back in 1996, and unfortunately, I was there when it happened. There are different types of review that have different types of thresholds. There's large project review, which I'm going to use Dorchester as an example, where you're adding 50,000 square feet or more. You have small project review, which has different thresholds, where it's 15 dwelling units or 20,000 square feet. There's also, under large project review, a substantial rehabilitation threshold, which is any rehab project that would cost more than 50% of the assessed value from the year before, according to the assessing office. There is what they call plan development review, which is similar to the South Bay. You need to have at least 1 acre of land and be in an area that allows this type of development to occur. If you are subject to or elect to go through plan development area review, you are also required at the same time to go through large project review. So it's parallel tracks. One that is really not affecting Dorchester all that much is institutional master plan review. And again, as I said at the beginning of the evening, those are for colleges, hospitals, and the like. Those are usually 10-year master plans that show dormitories, facilities for academics, athletic facilities, power plants, and the like. Article 80 is a public process. It's a very public process. There are, even for small project review where there might be 22 units of housing, there will be BPDA-sponsored events to talk about the proposal. It allows the creation of an impact advisory group, which is the group that speaks for the neighborhood in relation to this project. They get to weigh in on mitigation, on transportation, the number of units, the actual design of the building, parking, bicycle rooms if you want them. They are chosen, and the names are submitted by the elected officials to be nominated for this impact advisory group. There is no Article 80 process that doesn't have at least 3 or 4 public meetings, because a project that is filed with the BPDA that might require zoning relief at the Board of Appeal, and it actually happened today at the Board of Appeal, where it started at a certain number of units, But after community input and input from the elected officials, it is now down to this many units. So Article 80 is an incredibly public and transparent process. There really isn't much more without getting into specifics on specific projects. But when you trigger certain thresholds within the zoning code in terms of square footage or rehabilitation costs or the number of dwelling units, the community gets a very powerful voice in whether or not those projects move forward.
So one thing I'd like to add too is zoning is not precedent setting. Every single project that's heard is its unique decision. And we hear it all the time, well, they were allowed to put the deck on and they live across the street from me, why can't I? Each decision is based on the merits of the project. So precedence is never an argument that has any weight at the Board of Appeals.
Great, thank you. Council President.
Thank you for walking us through those processes. I appreciate it, Commissioner and Jeff. And now just going to some specifics related to those overall processes. In the case of as-of-right projects, that are denied, as in like the Popeyes case, obviously, who at ISD is notified?
Okay, the statement is wrong.
Okay.
As-of-right projects are not denied. As-of-right means they meet all
I'm
the
sorry.
statutory
As of
requirements. All right. I can tell you a short story about Popeyes, okay, so that we understand what happened.
Perfect.
Popeyes came into ISD, and its original project description was a takeout restaurant. At the time, takeout restaurants were a conditional use. Conditional uses are not as of right. They have to go to the Board of Appeals. So that's when they went through the process, and then they went to court and all that. And then somebody on their team realized a sit-down restaurant is an allowed use. And one of the first things I did when I was at ISD was explain what a takeout means. Because you can't go into, and I think Councilor Wu was very much with me in these discussions, you can't go into a restaurant, not finish your meal, and take the food out without it being a takeout. So it was just an oxymoron in my head. It just didn't make sense. So what we determined is that if more than 75% of your business is based on takeout, then you're a takeout restaurant. You've got to get an Article 36A license. If it's less than that, then you're a restaurant. You're a sit-down restaurant. And so with that distinction, they came back, refiled as a sit-down restaurant. We had nothing else that we could do than to allow it to proceed. And I know that was such a popular decision.
Were they allowed to? They were allowed to refile the very next day.
Yeah.
If
at that point, it was a new project, Councilor, because it was.
That's right. Is ISD made aware of the previous denial, or all of the attachments, whether it's letters of opposition or testimony or
No,
record of opposition?
We don't operate based on community process because ours is a linear evaluation. Is it 2 feet or not 2 feet? Is it allowed or not allowed? In zoning, all the use groups are listed based on the district and the neighborhood, so it's not a gray area to us.
It's just a new project, starting a new process, no conversation about the previous application. If we wanted to change that, if we wanted to think about projects and just starting with those projects that were initially denied, and then say refiled to proceed as of right because they found an allowed use, like in the Popeye situation, how would we go about, for example, one, maybe adding a sunset provision where, for example, they have to maybe wait a month or 3 months, or two, the follow-up question to that, requiring, for example, that ISD is made aware of the previous denial or...
You're going to introduce subjectivity into ISD's decision-making process. That would be counterintuitive to what our mission is. We are the enforcers of the laws. I get nervous every time somebody wants to just change something without specifics. Because you've got to be careful of, the unintended consequences of your decision. And what we try to do, and Jeff and I spend many hours discussing these things in a vacuum, well, what would happen in this scenario? What would happen in that scenario? So, not that we object to it, because, we don't have a voice in that, but I just make sure that when you go through the analysis of what you want to change, what are the possibilities that could be bad about the decision?
So I think there'll be more conversations to weigh the possibilities of anything new. But I would at least like the community to understand, and these are questions that came up from community as well, what would it take if you wanted to change it so that there a sunset provision, for example, is required? Or at least there's a delay in time in which an applicant who was previously denied would be able to come back to say ISD for an allowed use after being denied on a
I
conditional
brought a
use.
present for you.
What is that?
This is the Enabling Act. This
Does
is what
seem-
has to change. That's one part of it in the process.
It is one part in the process,
Yep.
and it's not a simple process. It would take a home rule petition before it goes to the legislature. And I forget the percentage of the legislature that would have to,
It's a high number.
so.
But
No, that's how, just a home rule petition is necessary.
Home rule
This
petition
is-
would have to
this
go
is
up to the
more-
State
Less so
House.
from my knowledge, more for the community's
Right,
knowledge
because it is
on
a
the
state
process of
law.
what it would take.
So the city of Boston is not subject to the Massachusetts state zoning law. We have our own Enabling Act, Chapter 665 of the Acts of 1956. And I believe maybe the last time they were amended was 2001, I believe. So it's not something that's done willy-nilly.
it can change. There's no doubt about it. But it's a process.
In terms of the notification, does any notifications go out by mail or email?
Our notifications go out by registered mail
And to whom? The owners or tenants or
to
just
the
owners?
owners. We have no list of tenants in the city. So it goes to the owners as identified in the assessing maps.
So if, for example, the owner didn't live at the unit in which, like in Dorchester, I'll just say an address, 75 Ocean Street. If the owner didn't live there and say lived in Milton, would the notification go to the owner in Milton? How would we go about changing it so that the owner or the tenant, the person occupying the 75 Ocean Street location, got the notification as well?
We'd have to know who the tenant is. And we don't track that. So that's the thing.
Could you do a care of?
I'm sure you could, but it's, all those notices, I mean, like we do neighborhood services, flyers to neighborhoods. We put notices in newspapers. I think it's the Boston Herald that it goes into. ONS does take it out to communities. They're supposed to let you know when projects, especially concerned ones, are there. We can describe whatever process we want. The 300 feet is based on...
That was another question.
yeah, that was the next question. I was
Thank
ready
you.
for this one. Is based on the court system. Because in greater than 300 feet, the judges have made the determination that the person objecting would have no standing, that project may not have any effect on them at all. And so that's where the 300 feet came from, and that's been in place for I don't know how many years.
So in order for us to change that, that would have to go through going against or doing something in the court systems to change that?
No. This is the interpretation of the legal departments in the city, that based on the condition of standing from judges, 300 feet satisfies the judge's requirements that the person has standing. You start getting, if you start reducing that, then there are people who may be excluded who are impacted by the project.
If you wanted to expand that?
That's a process rather than an ordinance.
So if you wanted to notify tenants, for example, who lived at 75 Ocean Street, or expand that 300 square foot radius to 500 square foot radius, that would be a matter of policy change,
Process, not a policy.
or within the city of
There's not a
Boston.
written ordinance that says this is what it is. but this is the procedure that we have.
Policy or practice, but that's within our control versus the home rule legislation has to go to the State House.
That's right. And the reason for the flyers is to identify and let abutters know. Because, you know, again, we don't know the names of all the tenants in the buildings in the community. So we make the applicants do flyers, and ONS does flyers as well.
I'm going to turn it over to my colleagues for questions, and I can come back for a second round. Thank you.
Thank you, Madam President. Councilor Janey.
Thank you so much, and thank you guys for being here. Just to follow up on the 300 feet, so just to be clear, to change the abutters definition, which is the interpretation of someone in the city of a court decision, what would have to happen to change that practice, to expand
In
it?
the simplest form,
Yes.
the mayor tells me to do it.
Okay, easy. Well, maybe not so easy, I don't know.
Kim, is that right?
That's good.
Kim is the assistant director at ISD for planning and zoning.
To do both?
Well, I think, if I can, because my job and hers, we always argue.
Thank you, Commissioner.
The ordinance tells
This would be
me
in
the
addition.
bare minimum I've got.
Right, that's right. This would be an addition.
I can go further than
That's
that,
right.
but I cannot go less than that.
Right. So just the mayor is telling you to do it. Earlier, you mentioned that there's criteria for deciding if it's an abutters meeting versus a larger community meeting. What is that criteria?
That's ONS. I can't
Okay.
speak to that.
Okay,
I mean,
that's fine.
Basically, my interpretation, and I will get yelled at for saying this, I'm putting a dormer on my house. That affects my immediate neighbors because they're going to see it. I'm putting up 10 units of new housing in what was a 3-family. That affects a community. Article 80 projects affect the city. So that's the gradations that I use. But ONS, they have a much better sense of every community, and they know what projects should go forward, and they're the ones who describe what should happen with that.
So if I own a property and want to renovate my basement, let's say, and I have to get a variance through zoning, how is that then, how does that impact the larger neighborhood? If you're just taking, you know, the unfinished floor, putting in a floor, some insulation, an entertainment room, let's say, so,
Hypotheticals are tough to answer, and if you don't hold me to it, I'll tell you the answer. A basement analysis, depending upon how big it is, where it is, would go through, in most cases, it would be a floor area ratio violation, meaning that the living space is getting bigger in the house. And one of the statutory requirements of zoning is that analysis, floor area ratio. It would come into us, they would ask for the variance. We would notify neighborhood services. They would then decide whether this warrants a community meeting or a simple abutters meeting.
okay. You also mentioned there had to be legitimate reasons to want an appeal. What are some of those reasons?
Well, a judge interprets this all the time because when you go to appeal, you go to a clerk's magistrate and they determine whether you have standing or not. If it negatively impacts things, Kim, you're the lawyer. Give us some examples. It's easy to tell you things that are not affected.
She should come up here.
Sure,
so
come
she
on
can be
up,
on the
Kim.
mic and on the TV. Thank you, Kim.
No problem, Counselor. So it really depends on the court's version of how they would interpret someone's damages. So as Commissioner was mentioning before, going back to the 300-foot interpretation, typically in order to have standing before a court to file an appeal, you have to prove to the court that you are directly impacted and harmed, resulting in some sort of damage that the court could actually consider and litigate.
Okay, and then this is kind of off topic, but it is about, notifying neighbors. So, not so much as of right building, but let's say demolition. Let's say there's a house, and that someone comes and tears down half the house. So this is an actual scenario in my district that has happened. What kind of notification, just say I have the permits to do such. Say I've done everything right, that I've gone to your office as the person who owns this building. What kind of noticing do I have to do to neighbors in that area to let them know that this demolition will be taking place?
Nothing
and
is-
it affects parking, maybe.
And I know the specific project you're talking about, but nothing is that simple. I wish it were. When it comes to demolition of buildings, anything that's older than 50 years, 35 years old, 50, has to go to the Landmarks Commission for determination, whether it's of historical value or not. And that can be a community process, not always. So that's the first place you got to go to that. Then you got to come to ISD to get your permits for demolition. Now, demolition in and of itself is not a zoning problem, because you're taking down, you're not building. So there is no public notice.
So there isn't one now, but there could be. I mean,
Also,
I would
there could be
argue,
anything.
that if a building is being demolished in my neighborhood and I'm in a butter, that I would want to be notified that this is happening, if for only not to park my car there. I don't own a car, but if I had a car, not to park my car there, to be aware of the noise, the dust. My child has asthma. I don't have a child with asthma, but if I did, I just would want to be notified. I think it's just the...
Perfectly fair.
Right. So what would need to happen to ensure, is that just a practice change, or is that
It's more than a
back to
practice change.
policy
Huh?
change?
That would probably have to be a zoning article, I would think, or a city council ordinance.
There is a zoning article, Article 85, that governs demolition delay, that speaks to this process. And I would imagine it would catch those projects that, like the commissioner said, for those buildings that are 50 years and older. However, if there was something where somebody was just doing an addition to a building that was built 20 years ago and they needed to tear down a wall for whatever reason, it wouldn't be triggered under that zoning article. I mean, it's just, when you look at the bare simplicity of it, it's really just an alteration of the project. You're taking down a wall to maybe put something else up. But usually, when you are raising a building and you go through the demolition delay project, hardly ever is it an as-of-right project. The lots are just too small nowadays, and as we all know, those people that are putting up units, 9's the magic number. They always want 9 units, and a lot of the city is zoned for 1, 2s, and 3s. So anytime there's any sort of demolition, people want to go bigger. So there's going to be some sort of companion with the Board of Appeal, 9 times out of 10. And so that Board of Appeal process, in terms of notification, would get noticed. But in terms of buildings that are older than 50 years, I don't know if Landmarks has any process in place for something like that.
Not for the public notice piece. They do have a review and they have criteria that determines whether the building is significant. It could be the architectural style, did something civically happen in that building, George Washington sleep in kind of thing. And they can invoke what's called a 90-day delay, at which point the applicant is supposed to look at alternatives. Are there ways to save all or parts of that building to keep the historical fabric of the building? At the end of the 90 days, if they can't come up with something, then the building is allowed to be demolished. Now, to Jeff's point about big projects coming in, it's very funny. At ISD, we have people come in and, they're going to do a decent project that's going to involve taking down a building or 2. They apply for their building permit, and they automatically assume they've got a demolition permit. That's not the truth. They have to come back and get a separate demolition permit. But if somebody comes into ISD and says, we want to demolish this building, that's all we want to do. Except for the historical piece, we let them.
Okay, and one more question. If I own a house and it's a residential area and I want to perhaps open a storefront and I go through the proper channels within the city, are the neighbors then, are they noticed?
Only if the use is not allowed in the district. Again, you know, as of right.
So not allowed in the district overall or for that particular structure?
Specific to that address within the zoning maps. So if you're in a 1 and 2 family district and I want to put up a 3-family, that's a violation.
What if I have a 3-family and I want to take one of my floors and do a home office, open up a law practice or something?
Private, yeah, go ahead.
So the zoning code does address it. It's called an accessory use. And typically, I'll give an example and then I'll backtrack to. So if you were a lawyer and you wanted to hang your shingle out in front of your house, you're allowed to do that. You're allowed, and accessory use is allowed wherever that main use is allowed. So if you have a 2-family in a 2-family district and you want to open up a law, you know, you want to hang your shingle and run your law office out of there, you can. With the understanding that that accessory use is no greater than 25% of the floor area. So if you took a triple-decker on Adams Street and you wanted to run a business out of the first floor, live on the second, and rent the third, you'd have to go to the Board of Appeals because it is no longer an accessory use because you have exceeded that 25% of floor area.
So in that second example, though, the neighbors would be notified because it's going
Through the Board of Appeal
right,
process.
it's going to
Correct.
ZBA. And the first example, though, they would not be.
No.
So, and there's nothing currently that says that neighbors would have to be notified, even though there could be additional challenges with parking because clients are coming.
Well, it also can't be open to the public. So it's very specific. When you look at the zoning code, there is a whole zoning article, you know, dedicated to the parameters of an accessory use, whether it be a driveway, a shed in your backyard, a swimming pool, fences. For an accessory use, it can't be open to the public. So you can't have traffic coming in. You can't have people parking in your driveway. It's very specific. If you are doing that, it's not an accessory use. It's now a business use in a residential district. You have to go to the Board of Appeals.
Wonderful. Well, thank you all for being here and for answering those questions. I'm really grateful for the opportunity again. I think this is really important. I think noticing the public is very important, so I really appreciate this hearing order. Unfortunately, I do have another commitment and I have to go, but I wanted to thank everyone for coming out tonight, and I wanted to thank my colleagues again. Thank you. Thank you.
Thank you, Councilor Janey. I'm going to ask just a few short questions, and then before we take any second round from us, I want to take public testimony for 10 minutes. We have 4 people signed up, so if everyone sticks to the 2-minute limit, we'll get everyone in then. Some of these written testimony include some of the questions that we would want to ask anyway. So I guess just to frame it, it sounds like what we're hearing today is that there are some things that state law defines, like the number of days in the notice periods and certain definitions, but there's a whole lot that is kind of entirely within the city's decision point, particularly around, one, we're allowed to ask for any information from the applicants about their intended uses, right? So if we theoretically wanted to create forms that would ask you, are you demolishing anything? Are you going to set up this or that? We could ask for that, right?
I don't know if I understand the question. There's a performance standard. They have to tell us what they're going to do, but any question is too big.
Well, meaning if we wanted to add a question in there, let's say we were very concerned about, will you have more than, will you have a delivery truck coming in more than 3 times a week for a certain number of hours? Or theoretically, could we amend the forms to ask that? And this is a bad example,
Yeah,
but
that's not a zoning issue.
But I'm not talking about, so when they come into ISD to file, and you ask for their name and their address and all those other things.
Popeye's the perfect example. From ISD's point of view, they could open. But from licensure, they couldn't open. So we don't ask, I mean, if you're going to have a loading bay in your building, we want to know about that. We would not ask you how many trucks you're going to have in a day.
But that question on the loading bay isn't from state law. It's from the forms that could be changed local,
Well, that's
at the
from
city
zoning.
level.
Well, that could also be from the Transportation Department. So if you have a project where you are required to have 1 or 2 loading bays, and you go through large project review through the BPDA, that will be discussed with BTD, because it's not only the developer, ISD, and the BPDA, it's all city agencies have a seat at the table, whether it be BTD, water and sewer, anything, Public Works. So I can't speak for BTD in terms of what time, loading docks can be used or the access to the loading docks. The zoning says you have to have one.
Okay. So once we have the forms that people fill out that ask various things, and different departments have different questions they want to ask, that information is public record, right? So when someone fills out a permit, anybody could see it, and it's really up to the city's discretion how we want to share it and who we want to share it with, beyond satisfying the minimum radius as interpreted from the court cases.
Anything that's given to me or told to me is public record. And so anybody who has a question about a project is more than welcome to come into ISD anytime, look at drawings, see what the application looks like.
Okay. So, and I know some of the folks who are going to testify will bring this up, but that means that the city could, and in some cases does, post online any permit that's pulled for certain types of projects, but we could expand that, anytime someone comes in to file for
They're available now.
all of the ZBA, all the variance requests.
So through our data set, through Do It, they set up public information on our website, so you can search for addressing for archival permits as well as pending permits.
So let's say one of the local neighborhood associations wants to just keep track of things. They can already go in and filter by zip code or...
Specific address, I think is...
Yeah, so I think it'd be ideal if there were a way to have a tag or a filter, just for any resident or even a neighborhood association head to be going through and kind of looking one by one is a lot. But if there were a way, as things were filed, that just as ONS and the liaison is notified, to connect that piece, or have a special Dorchester page or West Roxbury page where people could see what was happening. And similarly, I think the other ask, again, that will be heard is around which email lists receive those notifications. I know through the BPDA in particular, you can sign up to get any notices related to certain neighborhoods, but the city could theoretically broaden that if...
Sure.
Okay. Do those emails happen now with ISD is the question.
I'm sorry?
Do emails go out now from ISD?
No.
Okay, so I know we'll have more from us, but I want to take 10 minutes of public testimony. The folks we have signed up are Rick Yoder, Davida Andelman, Cynthia Lesh Johnson, and Sean Wheeler. So if you could go in that order at this podium over here. Again, please state your name and your address and keep your remarks to 2 minutes. Thank you.
My name is Rick Yoder. My wife and I, Lisa Beatman, lead the Mount Hope Neighborhood Association along the American Legion Highway Corridor. Pardon me if I've asked things that have already been answered, but I want to double check. On the question we were raised with the Popeyes getting a permit, building, and then finding out they couldn't get a license from the licensing board, why not reverse the process? You'd first get your license, which wouldn't cost very much if you got it, and then you'd know you could apply for a permit. And then you wouldn't be stuck with a building you can't use, the way we are now.
The easy answer is, depending on which department, they won't hear you unless you have zoning relief.
Well, I understand, but why can't that be changed? I mean...
Well, actually, Rick, respectively, if you could finish your testimony, well, let's have everyone do their public testimony, and then we can respond as a batch.
That's one question. The other is on the question, this is of notification. Last year, until sometime in the middle of the year, you could sign up with the city and get mailed notices to you by ward of any zoning appeals that were coming up. So you would know. You weren't dependent on your mayor's representative. You could see every single one. That's ended. There's no way you can sign up for an email list. So, one, you have to know, and it's not on the city website, that you should go to check the Herald, and that means checking it every day, or going to the website, special website where you can do a search, which is clunky, and I think it's intimidating to a lot of people. So basically, you can go to the city's hearing notices, but those are published like 5 to 7 days before the hearing, which is an absurd short of time for a neighborhood to be notified, to have time to call their counselors or notify other neighbors, to write up statements, to do research. 5 days, 7 days is ridiculous. It used to be, now if you went to the Herald, you'd find out, you could find out 4 weeks ahead of time, which is a little more reasonable. So my question is, why can't, as soon as the zoning board sends a notice to the Herald, why can't that be sent to an email list of anyone that's interested in knowing what hearings are coming up, so they'll get it the same day or the next day after the Herald publishes it? That would mean the neighborhoods would be well informed of what was happening in their own neighborhoods. Right now, much of us can get by us, unless you have someone who's dedicated to checking the damn thing every day. Here are some suggestions. Maybe you could, 5 suggestions. Speaking to what I just said, publish all hearing dates on the city website the same day they were published in the Boston Herald, creating a 4-week notice period. Second, when any city board issues a notice of hearing of the city on the city website, the city computer program will send out the same notice by email to anyone who has signed up for notices from that board. It will be publicized prominently that this option is available. 3, it will be clearly displayed in the email notice that anyone may submit a comment for the hearing by U.S. mail or email. These comments will be read at the hearing out loud if the person, as if the person was there to speak directly. Identical comments could be bunched and read just once, but all the writers' names will be read aloud. Number 5, end the practice of adding an applicant a few days before the hearing. Right now, that you can sneak someone in at the end and nobody would know. I'm not sure about in the zoning, but I know with the licensing board, you can do that. And I'm sorry that no one's here from the licensing board, but I think it's an equal opportunity for us to have some influence, because we can speak at the licensing board about whether a bar should go in, a restaurant should go in, anything that had to do with food and alcohol. They take public comment, but you wouldn't know it, and there's no way to find out about it other than what I was just saying. I hope that all makes sense. Those are my overall questions, and I have a list here. I have it printed out. I don't know if you have a copy. I can give it to you.
We have a copy.
Okay.
Thank you, Vic.
Thank you.
Davida?
Good evening, everyone. My name is Davida Andelman. I live at 94 Clarkson Street in Dorchester. I'm also chairperson of the Greater Bowdoin Geneva Neighborhood Association. I just want to thank the city councilors for giving us an opportunity to actually have a city council hearing in the neighborhood and during evening hours. It's not so much a problem for me because I'm retired, but a lot of people here, I'm sure, work other jobs, and it's much more difficult to get down to City Hall during daytime hours. So thank you for doing this.
And to really thanking our central staff.
Okay, thank you. Okay. So I'm a little bit familiar with as-of-right projects, and in my work life, I also had some contact with the sanitary code, the building code, and the zoning code. But as-of-right projects, I think that there needs to be a bit more respect in terms of people in the neighborhood. who are going to be impacted by what's going on next door to them, across the street, around the corner, and in back of them. And frankly, I don't think it's asking too much for people to be informed and get this information ahead of time. A few years ago, the Office of Neighborhood Services actually sent out notification to community groups, to community leaders about as-of-right projects. I think that lasted, maybe for a year or less, and then all of a sudden the list stopped. I would like to propose that, and I really apologize, Mr. Christopher, that not everybody can get down to 1010 Mass Ave during working hours and look at plans that are submitted and description of projects and who owns the project. A lot of people are not computer literate, and frankly, the ISD website is not that easily navigated for people who are not computer literate. So I would like to suggest that there be signage placed in front of wherever as-of-right projects are happening with the project description, the owner and the contractor's name, address, and phone numbers, the duration of the project and the permit number, and also the city phone number where people can call if they have issues with what is going on. I'll give you one example as-of-right project at 8 Marie Street, which impacted 6 and 10, the big fire that happened about a year ago. I happened to see work being done on the shell, and unfortunately that developer and I have had some contact and relationships over the years, and not particularly positive ones. I said, so what are you doing here? Oh, I bought the shell, and now I'm doing this major renovation as of right. Well, also the same person, his workers were throwing debris from the 3rd floor into the dumpster without a chute. So because I was up at Ronan Park walking my dog and I saw all of this, I was able to call my friends at ISD and said, please have an inspector come down here right away and stop this practice. But I knew who that developer was. I was familiar with that address, but not everybody has that information. So I think this is something really basic that the city can do, that city can require to have appropriate signage out there. And so frankly, I'd like to see this change. So thank you very much.
Thank you.
One, we do have 311, so you don't need to know somebody. You call 311 any time, day or night, or if you have it on your smartphone as an app and just send in a picture, you will get a response to that as we go through on that. And ISD is open on Thursday nights until 7 o'clock at night for that, and there are people there who will navigate the computers for you and produce whatever kind of documents that you need, so we don't leave.
I'm talking about ease of access and transparency here, and not everybody can get to 1010 Mass Ave. Okay, thank you very much.
Thank you, Davida. Cynthia.
Hello. Good evening, everyone. My name is Cynthia Lesh Johnson, and I'm representing the Codman Square Neighborhood Council. I'm also a resident of this community at 81 Brent Street. I want to thank the committee for hosting this hearing in our community. It's very important to do so, echoing Davita's points. I also want to thank the Commissioner and ISC for being here this evening, and Jeff as well, because you've been doing this for a very long time, so we appreciate all that you do. I know everyone in this room may be tired of hearing about Popeyes, but if you don't mind, I just want to briefly share the community perspective on how that process went about. And just for the record, we have as-of-right issues for development projects and use projects in Codman Square, but I'm going to focus my remarks specifically on this restaurant that was proposed in Codman Square and on use as-of-right. So back in 2016, a restaurant was proposed at 572, 576 Washington Street. It was a fast food chain establishment. You guys are familiar with them. Codman Square residents were very concerned about this proposal because we have many fast food chain restaurants within 4 blocks of where it was proposed. Right across the street we have one. You guys know it as McDonald's. Right 1 block further down is where the proposed restaurant would have been, and then 4 blocks from that, a KFC. So we have decades of experience of knowing what a fast food establishment in our Codman Square neighborhood looks and feels like. And so we issued this letter to the Zoning Board of Appeals dated August 15th, 2016, stating that we did not want this establishment in our community because of the density, the congestion, the parking issues, the double parking that would happen, the trash, high traffic. All of this comes with that fast food culture. So you guys know, highly processed foods, a lot of packaging, a lot of trash, a lot of litter, people moving in and out, not a lot of sit down going on. And again, we feel like the experts because we've been in this neighborhood for decades with 2 within 4 blocks of the restaurant that was proposed. The reason why this restaurant, it is Popeyes, had to go before the zoning board is because they were saying that they needed an extreme amount of takeout, because that's what fast food chains are. They are takeout establishments. It's fast, it's quick, it's takeout. And luckily, after issuing this letter and hearing all of the opposition from the neighborhood, the Zoning Board of Appeals denied this application with prejudice. So we were like, wow, this is great. Community process at its best. Residents did their job. This is amazing. Everything will be great moving forward. Because I didn't even mention all the health implications, right? The health inequities in this neighborhood, obesity, diabetes type 2. We're bombarded. We have enough. Our neighborhood cannot handle anymore. We cannot handle another chain. Unfortunately, after that decision, the applicant then went back to ISD, altered their application slightly, said that they would have less takeout than we all know that they actually would because we're very experienced with fast food chains like it in our neighborhood. And then, of course, was issued the permit as of right. So hearing the chain of events, it's just very frustrating for us because our understanding is that the intent of the zoning code is to protect our neighborhood from development or uses that aren't harmonious with our neighborhood. And I understand that maybe the zoning code might be outdated and it can't keep up with our changing neighborhood because it's changing so fast. But at the same time, we understand our neighborhood, we live in our neighborhood, and we know that we could not handle or sustain this proposed chain, which would then have us with 3 fast food establishments within 4 blocks. And when you leave here, please drive down Washington Street and see it for yourself. We could not handle it. And so that is our frustration. We can't have as-of-right projects just because the zoning code says that we can. Because the intent of the zoning code is to make sure that whatever is allowed as of right in our neighborhood is still harmonious with the neighborhood. And so the many projects that you're hearing about, and especially this one, is a perfect example of how it just isn't working. It does not work for our community. So my question is, how do we stay true to the intent of the zoning code? How do we figure out next steps that will actually carry out decisions, as of right projects that are not detrimental to the public welfare of the communities and are harmonious with the neighborhood? I've heard tonight that we might need to change the zoning code. Yes, that's a long and tedious process, and we think that's a great idea. We need to update it and modernize it for 2018 and for neighborhoods like ours. But we also need to think about permit applications that may not be realistic or just may not make sense, because for this specific example, we were on record of how it did not work for our community, how it was detrimental to our neighborhood and not harmonious with the neighborhood, as stated in the zoning code. Zoning board heard that loud and clear, but then somehow you could alter your application just slightly, and it's not realistic. Fast food chain culture type establishments like the one that was proposed there would be that regardless of what they apply for and what they say it will be. And so in those situations, I think we can act a little bit faster than having to wait for the long, tedious process of updating and modernizing our zoning code. Those are my remarks. Thank you for your time and attention. Appreciate it.
Thank you very much. Sean Wheeler?
Hi, my name is Sean Wheeler. I live at 75 Ocean Street. I speak a little bit at disadvantage here because, I don't represent an organization. I'm speaking as a neighbor who's concerned primarily about housing policy. So I appreciate your time. So I come here understanding that the outcome for this is not supported by the community. I'd like to share my understanding of the advantages of by right zoning and suggest that maybe to get the outcome that the community wants, it's not necessary to change the availability of as of right zoning, but perhaps there's other remediations. One that comes to mind, for example, in the new zoning for marijuana dispensaries, there's provisions for having stores being spaced out such that the school can, such that a neighborhood can handle it. And I think it's somewhat analogous to this fast food situation, and that perhaps we want to think about using other aspects of zoning instead of this as of right zoning. The reason I came is because the scope seemed very large. I was a bit worried that people would be proposing that everything turn into a case-by-case evaluation, which I would have very strong feelings that would be a disaster. In terms of positive aspects of as-of-right zoning, it can help bring the kinds of businesses the community want. Someone coming into Codman Square would see, okay, there is a restaurant here. We know that we kind of have a fast track because we're a restaurant too. If everything was by right, there would be a lot more, at least in efficiency, and possibly some businesses would not show up that we would want to show up. It helps limit development costs, and that's a necessary condition if we want to keep housing costs low in the neighborhood. The more time that someone has to spend with attorneys presenting to City Council, the higher the costs become for housing, and that's something that I think is important to call out. The negative aspects of if we actually were to drastically curtail as-of-right zoning, my worry is that every change would be subject to community input. And I don't know about you, but I feel like I spend far too much time at community meetings anyway. So streamlined processes make sense. I am going to highlight, I set a timer here, but I would like to highlight one thing that I'm not satisfied with for as-of-right zoning, as-of-right development. As-of-right is only as good as our zoning code. So one thing that we see now is that this as-of-right development, combined with low density, combined with high demand, is a recipe for displacement in Dorchester. What happens is that the community gets input on new buildings that are coming in, but loses sight that new buildings are adding new units, they're adding new affordable housing. By right development means, for example, there's an 11-unit building by Ashmont Station called Ashmont Landing that was simply bought, rehabbed, and new residents came in. There were no additional spaces for new people. There were no additional affordable units, so that is a net loss. I don't blame as-of-right development for that, but it reflects, there was a missed opportunity to have a discussion for an apartment building that would support growth in the community. And so I feel like that's a bigger piece, but one that I would like to call out at the meeting. Thank you very much.
Thank you. So, Commissioner or Jeff or Kim, did you want to respond to any of the specific points that anyone had brought up?
There are some general things, though. You talk about trying to streamline zoning because we understand the economic impact. Oh, sorry. You talk about streamlining zoning. One of the first things that we did when Mayor Walsh was made mayor was try to look at some of the simplistic things that don't make sense. There was an art gallery proposed on Newbury Street on one corner. It had lived across the street for about 100 years, the Puck Gallery. When it moved across the street, it was a forbidden use. We couldn't understand why an art gallery would not be appropriate on Newbury Street in Boston. In the conversation, again, I share with Councilor Wu, it was a bigger issue. I can't understand why any business area in our entire city shouldn't support an art gallery. So we addressed a lot of those kinds of things. There was bakeries, fitness centers. At one point, fitness centers weren't even allowed because the zoning didn't speak to it. So we are trying to address a lot of these things. I mean, we've got 30, 40 years of zoning that needs to be addressed and dealt with, and we're trying to look at that. So we are open to suggestions. We are open to discussions. The councilors have done a tremendous job of holding us to task on a lot of issues that are really paramount in their different districts and citywide. So, I don't want us to sound like we're saying no, 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 no. We're just saying that we got a process, we've got to listen to the law, and we're very open to making things go away. I mean, at one point you opened a restaurant, you needed a 36A to take out, you needed a 37A if you were going to have a radio. God forbid you were thinking about a pool table or a ping pong table. And none of this made sense to our mayor. He just said, we're trying to encourage business, which is the economic base for residential, and you need as much residential as you do business to support each other. And so we tried to deal with a lot of these issues to try to get them out of the way. Zoning change is a very big thing. It truly is. We just finished the total zoning change in South Boston, and it was totally supported by the neighborhood until it was enacted. And now we're into an iPod for the second year because people really don't think they like the new zoning. I personally, I'm an architect. I've done business in the city of Boston for 30 years. I think the zoning in South Boston is tremendous zoning. I think it preserves neighborhoods. It identifies growth zones and districts in a way that is not counterintuitive to creating stronger communities. It just takes time, but we continue to want to work with neighborhood people, with the council, to try to improve on these things. So we listen to everything you're saying. I'm not going to argue any of the points. They're all good points, and there's a lot of them there that we've been talking about. Sometimes it's just a hurdle of process, and we're trying to address that.
Great. Council President Campbell, you had some more questions?
Yeah, just to follow up on some of the suggestions that were brought up by folks who testified. So when it comes to notification, and right now, ONS, for example, they go out and they flyer. It sounds like we could change that and actually mail those units instead of flyering, for example, and possibly even do it through the notifications in different languages. And I'm saying this because I know, for example, for some good developers, they won't go through ONS. They've actually come to our office and work with us directly to do their own flyering and to do the notifications in different languages to ensure that not only owners of record get the notification, but that the tenants who live in the units also get notification. And then we see that the participation at a community meeting with respect to a proposed project is more well attended. So it sounds like there's a way in which to change some of these processes that are within our control versus home rule petitions that have to go up to the State House.
And to sound negative, what language do we mail it to in your house? What person do we mail it to in your house? We see so many, even the registered letters we send out about zoning issues, people say, we never got it, and we've got the return receipt. So, I think mailing to me is not the real answer. I truly don't. Signage thing, I think that's a great idea.
I think that was my follow-up too in terms of the signage.
If you go
that sounds
online
like
and
that's
look
within
at,
our control.
Atlanta, that's what they do.
But
Very
that's something that
successful.
we could do in the city of Boston.
Yeah.
And I'm going to push back on the language and the notification because that does have a good response. If someone receives it via mail and then they don't show up or they say we didn't know about it, then that's different. Right now, though, I use the example of the Ocean Street. If we're sending it to an owner who is receiving it in Milton, for example, but the person who's actually the abutter living at Ocean Street in Dorchester isn't receiving the mailing, then how can we make sure that the folks who are there in the community receive the mailing? I'd love to continue conversations about how we can change something like that. Signage, great. Going to a point that Rick made in terms of the notices going out to, say, the Herald, for example. But the previous practice, which I didn't know about, I guess there was an email that went out to different community wards or neighborhoods. Is there a way to either put these notifications after it gets to the Herald online somewhere on the website and more than 3 days in advance to give people more of an opportunity?
I don't know that it's 3 days in advance. That's the bare minimum that's going to be noticed before a public hearing.
The bare minimum, say that again, Commissioner?
That's the minimum notice that you've got to put out there before you can hear it on a public meeting laws. But we can obviously talk to ONS about doing this. ISD is not the mecca for the distribution of data. We have other things that are our primary responsibility. We do produce the lists. We absolutely do. Because we have to, because that's part of our responsibility.
This is helpful. Another question I had was just building off a point I think that Cynthia was making and that others have made too, some of whom couldn't be here tonight, which is a community that is working towards certain goals within their own community. So, for example, I'll use fast food since that's the topic of tonight. A community that is working hard to ensure that their main business district isn't overwhelmed with, say, fast food restaurants, or an overwhelming amount of the same type of business. So we've also heard, I think Councilor Presley also spoke to this, whether it's a lot of nail salons or liquor stores or hair salons. How do we ensure or help a community realize their values of, say, creating a diversified business district?
I was at Cynthia's meeting a couple
Yep.
weeks ago to talk specifically about Popeyes, and I used the analogy of Burger King because I didn't want to keep talking about Popeyes. You can, in zoning, you cannot say, we do not want Burger King. You'll end up in court in a heartbeat. But you can write zoning around, we don't want drive-ups, we don't want fast foods, you got to define what a fast food is,
Yep.
and stuff, and you can do that. But again, it's the unintended consequences. So we stop Popeyes from coming to the neighborhood. But if something like it comes in that the community does want, do we rewrite the zoning about that? I personally get nervous trying to dictate what businesses go where. The zoning does do that on an area based. There's business district, there's commercial districts, industrial districts, and that's the way that that's intended to control. I get nervous to say that we will have 5 nail salons in a quarter of a mile. So the 6th nail salon comes in and wants to open up. Do we say no?
The community might. I don't know. But I'm only looking at what are the options. So I know, for example, in other municipalities across the country, their councils, their city councils, have used legislation or other ways to do just that. Go into a community and say, what is it that this community wants? And rather than say, eat healthier, the community says, yes, we want to eat healthier, but we want better options. And the only options that continue to come here tend to be fast food restaurants. So these communities have decided to actually restrict the number of, say, fast food restaurants that can come in.
I'd love to hear some of that stuff, because I've never
So I
seen
think
that,
it's
yeah.
just, for me, posing the question of what are the possibilities that a community could explore for their community as to what they might want. So for me, the process, what does that process look like? Is it a home rule petition?
Community
Is it
had
an
great
ordinance?
success stopping Popeyes as it came in. That's the way it should be. There was also a KFC down, I believe, in
But it
Dudley.
still came.
It came because everything is allowed to be appealed.
Right,
You
so-
can't stop that process. That's basic.
Well, no, meaning the
Every
Popeyes
decision is
changed
appealed,
and they
yeah.
applied as of allowed use.
Yeah.
And they're open, right? And say they got their license. So I would love to hear from you, Commissioner, based on your years of experience and taking consideration some of that balancing that we have to think about that Sean brought up. What tools are available to a community to help them reach their goals for their community? And that may mean we don't want, for example, a ton of fast food restaurants. What tools could we give you to help with that, outside of saying, if the Popeyes came, let's notify somebody? That's obviously not enough. It doesn't stop them
The
from
tools
coming.
we use is zoning. It's the only way that you can really define a use group within a community. And it's a very ambiguous situation because you don't name industries, you name generalities around occupancy. That's the only way that I'm aware. I don't know, Jeff, Kim, if you have any other.
Well, there's one example of the formula retail ordinances, which is something that we have been talking about in Rosendale when a Petco wanted to move in and did move in because it was as of right. I never want to cheer when a business goes out of business, but Petco was fought so hard by the community, and now they just left because there were several great local pet stores in the area that people chose to support instead of Petco. And you could argue that, let the market run its course, but we also would have loved. We knew Petco wasn't the business that people wanted there, and we wanted to support the local ones, and we would have loved to have a different local business owned by someone locally there. So a formula retail ordinance that some other cities have enacted would essentially say, if you're a chain, a national chain, and they define it as if you have a certain number of locations across the country, if you have uniform packaging, or everything is sort of in a formula, standardized, you're essentially identified as a chain, then it's conditional in the zoning code, is what other communities have done. So there might be a community that does want Starbucks, but they don't want Popeyes, right? Or they might want CVS, but not something, a fast food. But when it's conditional, it does allow the community to have that input, as opposed to just allowing it to be completely as of right.
I think the Petco, and I know the one that closed, also had something to do with the fact that we made it illegal to sell live animals in the city of Boston. So, I mean, that's a way of effectively dealing with that. Because we didn't say Petco's, we said the product that you're selling is not what the city of Boston wants to see happen. So I think that is a very effective way to deal with, the city's wishes and stuff.
Great. Do you have any more questions, Councilor?
We can go.
Because we have another
Yep,
round.
yep.
Okay, great. So we have another, I also just wanted to recognize Joel, has been in the room. He's representing both himself as resident, I'm sure, but also the office of Councilor Lydia Edwards. So thank you to Councilor Edwards for having staff in the room. So we have another round of public testimony. I'd like to invite up Janine Berry, Victor Rodriguez, Stephen Godfrey, and Vivian Girard.
Oh, boy.
And I have some questions.
Hi, everyone. I'm kind of afraid of speaking in public, but anyways. I'm Ginny Barry from Mission Hill, and I would love to see the as-of-right automatic approval process changed. Right now, we have a development on Allegheny Street, and it's the Home for Little Wanderers, and we have a tiny little one-lane, dead-end street, and they just moved in as of right. They're building a group home. They're bringing in all kinds of troubled kids, and we already have a high school on Allegheny Street, Fenway High, and we have a ton of college kids, and it's just not the right project for the neighborhood. No one was notified until they started construction. The day before, we saw the permits out. We can't park here. And so they've been out, they ring the doorbell because they can't get their construction trucks up the street. We have to move our cars for them. It's a terrible situation, but there was nothing we could do about it. There was nothing our representatives could do about it. The mayor couldn't do anything about it, all because it was as of right. And I would love to see something change.
I just have to correct you. If it's the project that I know, it is not an as-of-right project. It was a small project review, and it went through the entire public process. Very familiar with the project.
The Home for Little Wanderers?
Yes.
Well, according to Neighborhood Housing Services, Mayor Walsh, Josh Zakum, Senator Chang Diaz, it's all as of right. According to your office, Mark Jacobs, Kim Tai. I've had numerous conversations. I wrote articles in the paper.
No, the issue that came up on that project was there a clinic or not? And
That was one of the issues we tried
was
to go
the issue.
after.
and they are not allowed to have a clinic. Their
Well, they did-
Their occupancy is limited, to dealing
22
with,
beds.
right? But they can have no medical procedures in there at all.
Yeah, I
So
understand
that one did go through the
And
process.
they lied about that to begin with, so there was a long process. But they didn't notice anyone in the neighborhood. They had a meeting the day before they started construction. That was the day they notified some abutters. All abutters were never notified. They've been blasting for months and months. And
It just started.
it started in November.
Again,
Yes.
I know we
Construction?
could,
Yes.
there's so many back and forths we could have about so many projects across the city.
Well,
So-
I'm just saying that this did not work for our neighborhood, and there was nothing we could do about it. We tried, every community group, every representative tried to, come help us out, and no one had any legal way of stopping it. So I just think that they really need to think about changing the way things go, because the whole community was against it. And we just couldn't do anything. So I think that they just need to, there has to be a change for this as of right.
Thank you, Ms. Berry.
Thank you.
Good evening, everybody. Hi, my name is Victor Rodriguez. I'm a member of the Common Square Neighborhood Council. Regarding Popeye, I was opposed from the beginning. The reason why I'm opposed is because our community needs some healthy food. We got some type of experience, we got different type of elements with our community, especially with the elders. I found out through Popeye because, like Cynthia said, they came out to us, but they found a loophole. there's any way that you guys can inform us that that loophole will never happen again. And I thank the council to be here. But a lot of our community, they're not for it. That's what I have to say. And my apologies.
Thank you, Mr. Rodriguez.
Thank you.
Oh, Steve, is Steven still here?
No, I have a
think he
question.
stepped out. Okay, so Vivian, please.
Yes, good evening, City Councilor and zoning experts. We appreciate you bringing the conversation to the neighborhood. I wanted to speak of a specific case that we still don't have we haven't received a very good response about it. I live, I'm Vivian Girard, by the way, and I live at 34 Ditson Street in Fields Corner, and I also represent the Fields Corner Civic Association. And we had a case of at 212, 214 Westville, where a developer with a poor reputation already purchased a triple-decker along with the abutting lot that the city gave away to the previous owner of the triple-decker at 214 Westville. And then this developer proceeded to build an addition, quote-unquote, a 3,000 square foot addition that's as big as the original triple-decker. And the land, that when it was pretty much donated by the city under the condition that it was unbuildable. And I live half a block down the street, and we never received any notification or anything. The addition looks small on paper, but it's actually quite big. And there was this already set a precedent, because the same block alone on Westville, there is 5 lots with the same restricted deed, 5 vacant lots that were given away by the city, supposed to remain open space. So now it seems like they can just do the same and keep on building. So the precedent is there. And then the other issue is the developer purchased the 214 Westville Street for $500,000 for 3 units. And then after doing the construction for the past year, now each unit is for sale for $625,000. So they displaced the people, quadruple the price of the units, have been very disrespectful and uncommunicative. So I wanted to know I'd like to know what's the threshold to get like at least neighborhood notification when a developer wants to build, again, a 3,000 square foot addition, and we didn't even know about it until we saw it going up. So that's my question. And also, if I can add a more general comment, we have this big issue in Dorchester and Fields Corner in particular, where we have a lot of very careless and greedy landlord developers. They have no knowledge, they have no curiosity, no interest in the community. They just come to do a quick flip, just like this one, quadruple the price of the property, displace tenants. That's a major issue. So this is more like for the city councilor, what can we do to stop developers who already have a bad track record, a lot of violation, a lot of issues with the neighborhood from keeping on going, they just keep on going without anything to stop them, and it's a problem. Thank you.
Thank you, Vivian. Is there anyone else who wishes to testify? Okay, please.
Good evening. My name is Teresa Latson, and I live on Greenbrier Street. And when I built my house, I had as of right. And as soon as I put my foundation in, the community called me and said I needed to come to a meeting. And the city said to me, let's be a good neighbor and go to that meeting, even though you have as of right. So I think that everyone should be a good neighbor. I think that Popeye should have came back to the community and said, we got our permit and we changed it. I think this is BS when you get down to it and we're saying we don't have to do this. If I had to do it and I had as of right, and I'm a resident, I'm not even a business person, when do we make the businesses be accountable to us? And I like what this young lady said. It's not harmonious with our community. We have obesity, we have diabetes, we have high blood pressure and heart attacks here. We don't need another fast food restaurant. And I'm beside myself because how can you guys not listen to us? And so now you get down and the guy has, or the woman has already built the business. They're losing money because they've already built the business. And we said we didn't want it in the first place. So, like he said, I don't even see him now. Why would we not do the license first, then do the permit, so that we know if they're going to even be approved for the license? But I just think it's BS when you say a business does not have to be a good neighbor. And you say to me, a resident, I have to be a good neighbor. And I think we have to change it. We have to change it.
Thank you very much.
What I'd like to say to you is, you are a good neighbor, and you did the right thing. And we advocate all the time that people do the right thing. But an as-of-right project has no law that forces it. There's no ordinances about good behavior or good neighbors. And we advocate all the time that people come back on any project that they're dealing with to let their neighbors go. The way we look at it is, if I'm going to live in this neighborhood and the first thing I do is alienate my relationship with everybody, how well am I going to be welcomed? So I totally agree with you. And I wish there was some way to force people to do this.
Well, someone else said that we used to get the permit notifications. And I'm a leader. I chair United Neighborhood Association. And I got those emails. And it was a great help because then I could look at it and say, okay, this is going to directly affect my community, and what do I need to do? And then I would call my constituents and I would say, what is it that we need to do? Are we in agreement with this? Do you want me to write a letter of denial? What do you want me to do? And I think even if we're just notified that we know what's coming into our community, that would make the difference. And I don't understand why that stopped, because that's an email, that's a quick fix. So I would request that we start that again, and I would request that the community's voice is heard. We are important, we live here. Like I tell everybody at my meetings all the time, I done put all my money in this house, I'm not going nowhere. And you know I will be after you, buddy. You know I drive you nuts. But I'm just saying, we need to do some things differently. And I want to thank all of you guys for coming out. I mean, it's a weeknight. You guys have young families, but we have to, and our voice needs to be heard. And it drives me crazy, it drives me nuts when I feel like our voices are not being heard. And I think that the seniors that were part of that first denial, they weren't heard. And is it because they're seniors? It's not right. So we have to do things differently. And that falls back on ISD. And I don't know how we fix it, but we need to fix it. And even if it's just a simple email so that the community knows in advance what's coming in, and then we can notify whoever it is that we need to notify. But we have to do things differently. This is a mess. And now I'm with Andrea. You're kind of mixed because now they've got that building up there and they're not making any money. And in one way they deserve it because they didn't listen to us. So where do you go? But if we don't use it, it's an eyesore. So we need to do things differently.
Thank you very much.
Thank you, Teresa.
All right. And anyone else, if anyone else wishes to testify, feel free to come on.
Hi, my name is LaQuisa Burke, and I live in a community. I run the Western Washington, the Wild Coalition. We handle streets down on Norwell Street, Millett Park, Spencer, Thane, Wheatland, and Afterwall Street. My question is today, is there any way to put like an addendum on this? We've had a lot of development within our own community, and fortunate for us, we've had socially responsible developers. We haven't had people just coming in, just doing whatever they want. We've only been dealing with one developer, well, two, the City of Boston, Oxbow, and then we've been dealing with Mr. Travis Lee. And they have both been very good to us. They have both come out whenever there was a denial. They always came out. But I just think that it's morally that's just who they are as a company, and they want to make sure that they look well in the eyes of the community and they are participating into what the community wants. We did ask for affordable housing when he came in and he wanted to build a 6-family house. we asked for him to make sure that we get at least 2 of those units at an affordable price for people that's in the community for what you guys say is a affordable price, you know? $60,000 a year, I'm not sure. I don't make that, you know, so I'm not sure who makes that living around me, but I'm sure there's somebody because you guys are saying that's the median. But he was very good about coming in. Whenever he got a denial, he would come in and he would let us know. So I'm just wondering if there's like an addendum or something that you can put out there for the developers to sign that say they're gonna be socially responsible, they will listen to the community and take all those things into, I mean, it's all nice to say, yeah, we will do that, but if you actually have to sign something that holds and binds you to that, then maybe that will be a little bit better for the community, and then the community will feel like their voices are actually being heard. I mean, as an African-American woman living in the city of Boston, we always feel like our voices are not being heard. So when you guys decided, or Popeyes decided to come and the community decided they didn't want it, and just because they changed 1 word or 2 words on the application, that doesn't make it okay for them to still be here, especially when Dorchester is considered a food desert. We have nowhere to eat here. Pizza and subs, nail shops and barber shops. That's all we have. So it's like if we can get better options, things that the community may want besides these everyday regular things. I don't see Popeyes going down Seaport. I don't see them going down South End. But why are they trying to come here? You know what I mean? Like, so it's like, I think that these companies and these developers need to be able to sign something that holds and binds them to being socially responsible to what the community wants. Thank you.
Thank you very much.
Good evening, and thank you for coming. My name is Bridget Wallace, and I'm actually a resident of Roxbury. And so it was mentioned earlier this evening regarding the development that's taking place in Roxbury and the Plan Dudley process that is currently underway. And the community has voiced concerns time and time again, one, due to the density that is sort of just inundating Roxbury, and every lot, every buildable parcel, they are trying to just jam development in there. And the community has stated time and time again, that we need to balance that. We need green space. We can't just, because I should note that Roxbury has the most buildable lots that's remaining across the city. So all eyes have been focused on Roxbury. And we do want development, but we want equitable development. We want inclusive development. We want development that's not going to exacerbate some of the health concerns that we've talked about this evening. We want development that doesn't displace people. We want development that is done in a way that's fair and that listens to the people that are currently there, not just for the people that you are hoping to move into the community. So I would ask that we look at zoning laws, because I know there's one parcel, and it's the Rio Grande, and that would mean that we are looking to have a downtown-sized building in Dudley Square. And I know the Guscotts, and Ken Guscott was a wonderful mentor, but I think we really need to look at how we are developing and planning neighborhoods. So Roxbury, we did that work. We had a Roxbury master plan, but now the city has carved out a Plan Dudley. So it seems like you're taking away the voice of the community because we've already had a master plan. I was a part of that master plan some 20-odd years ago under David Lee when they were putting together that plan, and now here we are looking to execute that plan. So to take the power away from the community allows for things to happen like a Popeye and like other development that you don't want to see when you institute a plan within an existing plan that already had community input. So I would just ask that we look at the zoning laws, we look at how we plan neighborhoods in a cohesive way, we look at the commercial districts, and you know, you should plan in a way that you put in cluster businesses so that the businesses that are there can support each other. They're not all the same type that are inundating just one area. And we understand, particularly for minority-owned businesses, to open a barbershop or a hair salon, they're low-barrier businesses, right? So you don't need it's not a lot of tech, not a lot of innovation. You have some money, you can pay the rent, and you sort of have a certificate, and you go in and open that. But the neighborhood wants more. It wants a diversity of services and goods in a community, and it doesn't want to be the home of some place like Popeyes. I mean, Dudley Square is looking at that, and we still do have a number of fast food restaurants that are in the area, but luckily we are entertaining the idea of putting in a sit-down restaurant, not only for the purposes of just having a sit-down restaurant, but so that we build wealth, right? So that our dollar circulates in our community. So that is the other half of planning a community and planning it well so that wealth can circulate in the community and we can build equity. Thank you.
Thank you very much.
Hi, I'm Andrew Sharp. I'm so glad I came here. How I've heard about this, thanks Andrea for the Twitter and the stuff. So we got to look at the way we communicate now. It's 24th century, so I agree with what you said about getting the information out. Just like what you did, post on Twitter, post on Facebook. So we've got to look at that way in which, one of the things I would love to see for the development, we're not looking about youths. We want to get them out of the crime and stuff, but I don't see any facility, sports facility, those kind of stuff. So if we can look at development that is focused on the youths also, I would love to see Boston has training for youths like my Caribbean people youths to become like Usain Bolt and those kind of stuff. So we got to change perspective on various development, not just housing alone, but for other facilities there in our community. Because like that center would have been good for CVS or some kind of youth program center right there, not Popeyes. Thank you.
Thank you, Andrew. Would anyone else like to testify? Okay, then at this point, I'll leave room for any of our panelists or the council president for if they wish to make any closing statement. But I'll just say, from my part as committee chair, my obligation or my commitment is that I think there are some follow-up pieces from here. It sounds like there's a couple different tracks. One is that there are some communities that do want to propose zoning changes, either to streamline for uses that they do want to see and exclude others that they don't want to see. That'll be a longer process. But then there are also some recommendations just on the notification, which are squarely within our jurisdiction to change. Do we post things online? Do we expand the radius? So the committee will work with the sponsor and colleagues to put together a list of recommendations based on what we heard tonight. Maybe we'll have another working session or so to collect more and add that, and then we'll sort of formalize that list and then run it back through the administration to see what's possible to tick off quickly, what might take more time, what's a matter of resources, et cetera. That way you have an organized, written something to respond to. So that's it for me, and I want to thank everyone for being here tonight and taking the time to participate. Would any of our administration reps like to comment? Well, thank you so much for joining us. We so appreciate your time. And Council President Campbell.
Thank you, Councilor Wu, and thank you guys for being here. It's warm and we don't have water for you, so I appreciate that you guys are here and that you did in the evening and came into community. I really appreciate it. And thank you to the residents for coming. I see a lot of my District 4 residents. I really appreciate you guys being here and offering your perspectives, which aren't all the same, which is awesome. You know, this is going to be a conversation that requires balance and striking a balance and striking compromise. But what's most important is that we hear from each and every one of you your concerns as it relates not just to as of right development projects, notifications, your suggestions, but also what you're feeling. There was a lot of frustration around the Popeye situation, the Taco Bell situation in Rosendale. So my goal is to take that frustration and channel it into some solutions and ideas so that we don't have the same problems show up in a month or 2 months or a year. So I'm going to work with Councilor Wu as well as some of my other colleagues on some solutions. I think some are short-term and things we can do in the immediate, and then others I think are more long-term. And I will lean on the expertise of folks who've been doing zoning for a long time. This is not an easy an easy issue to tackle when you talk about changing the zoning code, particularly as it relates to us engaging with the State House and requiring and asking them to show up on this too. So it's not, everything is not directly within our control, but we'll continue conversations. I think a working session is the next step. I will also add that Councilor Edwards also had some questions around zoning, specifically variances and the standards for approving those. And we answered some of that, but there's still some more to be answered, which we can do in a working session. And there was also some questions around enforcing, once an as-of-right project is constructed and operating, how do we enforce the requirements that they how do we enforce the requirements that they said that they were going to adhere to? So those are questions we can also ask in the working session. But this is not a conversation that we will end tonight. Thank you again for being here, and we will let you know when the working session will be scheduled as the second part of this conversation. So thank you again. Get home safely, and thank you, Councilor Wu.
Thank you. This concludes.
And thank you to Central staff. It takes a staff to actually set up in a community to do a city council hearing and to follow all of our laws and regulations. So thank you so much to Kerry and Juan for being here and for setting us up and making it so easy.
And this concludes docket number 0449, order for a hearing regarding as-of-right zoning projects and exploring imposing notice requirements and other community-informed conditions.